Hi, everyone, and welcome to Understanding the Changing Landscape of Guardianship, What E-MDTs Should Know. I'm Marty Washington. I want to before we get going, I just want to give a nod to the Office on Victims of Crime for not only funding this presentation, but also for your projects. And remind you that the opinions, findings, and conclusions that you hear today are those of the author and are not necessarily the viewpoint of the Office of Victims of Crime or the Department of Justice. For those of you who are new, housekeeping, please, if you could just stay muted unless you're talking to cut down on background noise. Rename your Zoom so we know what name, if we are having a conversation, we know what name you'd like to be called. You could either raise your hand or drop a question in the chat. We will be keeping an eye on the chat, so you can ask questions that way. And if you have any issues, please email me at mwashington@ncall.us. And with that, I'm going to turn it over to our speaker today, Anita Raymond. Anita, take it away.
Thank you. Thank you so much, Marty. I am indeed Anita Raymond. I'm the director of the Center for Excellence in Supported Decision Making and our private pay care management and consultation programs at Volunteers of America, Minnesota. I am based in Minneapolis, Minnesota. I will try to remember that I'm talking to people from throughout the United States and recognizing that Minnesota law may be very similar to your law, and also we may have to talk at higher levels, but I'm coming to you from Minnesota. I'm really happy to be here. I do believe you've received more of my detailed biography and some of the newsletters and materials leading up to today, so I don't want to spend more time, and I don't really like talking about myself. So we will delve in. I know Marty turned off their camera, but I believe that you have or will receive the handouts. You will receive slide deck. So that's always a question.
That is correct.
Okay,
yes.
Thank you. Thanks for doing that. And special thanks to Marty for all of their support in getting us here today, and to Kylan and Lisa and everyone, again, for hosting this and for asking me to come and talk. I'm really excited to do so. So I intend today to start with a brief high-level discussion around the changing landscape of guardianship. And since guardianship is frequently considered as a response to maltreatment, I want us to make sure we're using it appropriately with a solid understanding that, for example, what can look like incapacity and a need for guardianship might actually be a flawed or inaccurate view of a person's vulnerabilities and situations. We're going to talk about those aspects and then delve into unintended consequences of guardianship, as well as more conversation on less restrictive alternatives. And I do know that you had a conversation last month about guardianship and powers of attorney and healthcare directives. So luckily, we don't have to then repeat time on what those are. You can reference back, if anybody's here today that missed those, you can reference back to that training as well. Another word about Minnesota law and language. I'll talk a lot about language today, but you may hear me use the word maltreatment more than I might say elder abuse or abuse. In Minnesota law, in our vulnerable adult statute, the word maltreatment is used to encompass, it's really that umbrella term, to encompass all forms of abuse against vulnerable adults: physical, sexual, emotional, financial, caregiver, and self-neglect. So I'm sort of trained to use that umbrella term of maltreatment, but know that I also mean elder abuse in general, because that might be the umbrella term you use or that your states uses. Okay, so let's get started by laying the foundation for guardianship. Again, acknowledging you had that session on some of the technical aspects of it last month, so we're not going to talk about those pieces. But what I do want to talk about is guardianship and supported decision-making and alternatives kind of from a slightly different lens. In situations of responding to episodes of maltreatment and the goal of avoiding future maltreatment, putting safety plans in place and so forth, involved professionals and MDTs often turn to guardianship. Indeed, serious situations you're dealing with call for serious interventions. But I want to talk today about the fact that we really can't ignore the fact that legal tools don't automatically and with certainty prevent maltreatment. So even when we're recommending or even facilitating guardianship or the appointment of a legal fiduciary, we need to build in extra accountability with the acknowledgement that just having legal tools in place don't automatically stop, prevent, address maltreatment. So we have to acknowledge that. And in fact, what does help avoid maltreatment is, again, even when we put these intensive tools in place, recognizing that additional accountability needs to be built in. Whatever the tool, abuse can happen. Whatever the profession, abuse can happen. Legal tools and systems and licensure and all those all those systems simply in and of themselves don't prevent abuse or maltreatment. Accountability is what helps protect. Additional eyes on a situation, abiling isolation. And sometimes guardianship relationships can become very isolative. We appoint a guardian, now go do the guardian thing, and there aren't as many eyes on it as we might think. So having accountability, having eyes on situations, having a mechanism in place to report suspected abuse and systems being in place to respond to those episodes of maltreatment are in fact the key. And of course, the role of MDTs in that is significant, and very grateful for the emergence of MDTs and E-MDTs as in the case here. Okay, so let's talk a little bit more, again, high level, but talk a little bit more about that landscape of guardianship. You probably know, as I do, you probably see a lot of the same stories, that there are dramatic stories, fictionalized and in real life, of abuse and maltreatment within guardianship. Systems, laws, news stories are shining spotlights on guardianship, on not only the protections and the benefits that guardianship can offer, but again, those dramatic stories of people getting caught in overly protective guardianship arrangements or abusive guardianship arrangements, and recognition by our systems and laws as a result that safety can't be the only consideration, but rather we need to be in the crux of my work, and the crux of our conversation today is about trying to find the balance between protection and quality of life. More and more states, for these reasons, are emphasizing guardianship as a last resort. And that's because we are recognizing more now than I've been doing this guardianship adjacent work, supported decision making. I've been doing this work collectively for over 30 years, and recognizing that our national policy and laws, our state laws and policies, again, depending on your state, certainly, but these are law and policy recognize the right to self-determination, and that people are entitled to receive accommodations for their disabilities, that people are entitled to receive accommodations that maximize their independence. And this is shown in the Older Americans Act, the Patient Self-Determination Act, Americans with Disabilities Act. It's not just for physical disabilities, it's for cognitive disabilities as well. The Olmstead decision, a federal decision about people with disabilities' right to community integration. All of these they've been around a long time, and emphasize the right to community integration and self-determination and inclusion. But it hasn't always been discussed, the sort of intersection with guardianship. And that's why I'm so glad to be here today. That's a lot of what a lot of us are all recognizing, that guardianship is also part of the system that may impinge on people's right to inclusion and self-determination. So we want to overlap these and view these laws really, really together. Even the National Adult Protective Services Association's Code of Ethics clearly support the idea that we must balance safety with the right to self-determination, that quality of life is also an important factor. It's right there in the Code of Ethics of NAPSA, in the guiding value that APS actions must balance the duty to protect, yes, and balance it with the vulnerable adult's right to self-determination. I've highlighted key pieces for our purposes today. NAPSA's principles state that adults must retain all their civil and constitutional rights. They retain the right to live their lives as they wish, manage their finances as they wish. People have the right to make decisions that others don't agree with, as long as they don't harm others, and with some other qualifications. But as a baseline, we ought not be turning first to guardianship even though we might be in some really egregious situations. Further highlighting that case planning, determining our interventions, where we're going to go, how we're going to support a person, that case planning ought to be maximizing the person's independence and choice, again, with the qualification to the extent possible based on the person's capacity. We ought be using the least restrictive services first whenever possible. Community-based services rather than institutional, supporting a person to make decisions, my words, that's not in the code of ethics yet, supporting the person to make decisions versus taking away the right to decision making and give it to someone else. We ought to use family and other informal support systems first, as long as it's in the best interest of the person. Ultimately, it's really, when I first read the code of ethics, really punched me. Do no harm. Inappropriate intervention may be worse than no intervention. That's really heavy. All of this to re-emphasize, and as we'll further delve into as we go forward today together, societally and in our laws and practices, we do now better understand that there's more to our roles, more to our purpose, more to our interventions than merely finding the safest response possible while ignoring the impact that those safety choices might have on our person's goals, wishes, and quality of life. We have to look at both of those pieces. Now, I like to say, and I'm talking to myself as well here, it's easy to feel blamed or to start internalizing and feel a little bit of shame or regret that if we contemplate some of the things we've done in the past in our role of supporting and protecting people, maybe we've done inadvertently with good intentions, but maybe we've harmed people in the past in our efforts to try to protect them and look at safety as the number one goal, as safe as possible instead of as safe as necessary. I know I struggle with this regret sometimes, but I also take comfort in the advice of the late great poet Maya Angelou, who says that we should do the best we can until we know better, and that's what we've done. And now when we know better, let's do better. So part of incapacity, sometimes it's surprising, it might feel a little jolting to interject or to start with issues that aren't about a person's neurocognitive abilities, but thinking from a higher level about the importance of approaching maltreatment cases with that lens of understanding the impact of ageism, ableism, trauma, poverty, culture, on other considerations on an individual. It might be easy to mistake in external factors that impact a person that looks like incapacity when it might be in fact an external factor or our own misunderstanding of the reasons for a person's choices. So it can look like self-neglect or caregiver neglect. So I want us to think about a little bit more about the impact of some of these isms, some of these other potential effects or causes before we go into guardianship. But I also know you did have a training on ageism in May, so I'm going to go quicker than I otherwise might here. If you don't already know about the resource of the National Center to Reframe Aging, and there's a live link if you get your if you open your slides rather than printing them, looking at them in your email, and then you can click on many links I've given you throughout the slides. The Center for Reframing Aging is dedicated to ending ageism by advancing an equitable and complete story about aging in America. So more than just older adults are victims and frail, but are also but are at the core whole human beings with histories and wisdom. Their center is a trusted source for proven communication strategies and tools to effectively frame aging issues. They have a lot of thought pieces and articles and tools, and again, live link in the handouts. But some of their work and some of the webinars I've attended help inform my views and what I bring to this kind of training. As they talk about, and again, I'm just going to mostly throw this at you and then move on, but think about how our language frames how we view the people we're serving, how it might set expectations of what we should do next. And if we had more time, we would have a group communication, a group discussion. Like, think for a moment and share with each other, if we had more time, what image forms in your mind if someone comes to you and starts talking with you about, I've got this vulnerable adult, they're low functioning, they can't make their own decisions, they make poor decisions. What picture do we get in our mind? And before we even know more, what do we start thinking about? I've got to intervene. I've got to do something just by this language. But how different of an image might we form in our brain if we were presented with this is a person who's living with vulnerabilities. This is a person who needs a lot of help with navigating complex decisions, but they're really pretty resilient in how they navigate through their day. They're able to make a lot of their decisions, but they've had some trouble with scammers and recognizing scamming. How different might we focus our attention, our thoughts, our next steps if we're presented with a description of a person in a way that honors their wholeness, not just their deficits and frailties? Sometimes I like to talk about, now we have to use the term vulnerable adult. It's in our statutes. We have to use terms that are legally defined. We have to build our programs around. We have to get funding. We have to use the correct terms for sure. And in conversations, maybe we think about a vulnerable adult or a person in a precarious situation, a person at risk of harm, or a person who has experienced harm or maltreatment. So just again, what's in a name, thinking through those pieces. Okay, now I want to shift gears a little bit, and I'm watching Lisa. Thank you, Lisa, for your affirmations. It's nice. Totally honor people having their cameras off, and thank you also for that. And I'm also trying to keep an eye to somebody get my attention if you have questions. As I shift gears to a slightly different aspect of our conversation, from the language of vulnerability to capacity, as we start thinking about which interventions are most appropriate based on a person's ability to understand and participate. We know that a person who's capacitated can legally enter into some protective arrangements, like a trust, a power of attorney, advanced healthcare directive, whatever it's called in your state. The capacity impacts whether they can sign a release of information, and a person who's not capacitated might need a guardian. But I want to argue and just put it out there quickly. Hopefully, this is a review for many of you. It's not that easy. It's not binary. It is not static. It's not global. Capacity fluctuates, and we have to remember that. Capacity to make a decision depends on the decision. So it's just, I just sort of internally, silently roll my eyes when someone says they're incapacitated, they can't do that. And why? Well, a screening score, a diagnosis, a psychologist said so. All due respect to all of those, but have we actually assessed their capacity for that particular decision? It's not global, it's decision specific. We need to start with a presumption that the person is capacitated. Isn't that how we all want to be considered? Start with best intentions about me, right? Same thing with somebody's capacity. And also making sure that we're thoroughly, or someone on our team has thoroughly explored, for example, medical conditions that look like a dementing illness, a neurocognitive disorder, but actually maybe is untreated depression, maybe a brain tumor, a vitamin deficiency, an infection, dehydration, medication errors, medication interactions. So the question we need to be asking is not, is this person capacitated, but rather, is this person capacitated to make this particular decision? And by the way, have we ruled out other things that may look like incapacity? And also, by the way, what can we do to enhance the person's capacity? So even if a person is dealing with mild cognitive impairment, mild, moderate stages of neurocognitive disorder, what can we still do instead of just labeling them unable? How can we, as professionals, embrace our job about how we approach, how we enhance people's capacity? Are we approaching them for the conversation about whatever it is going on, whatever decision we need, or whatever intervention or recommendation? Are we approaching them at their best time of day for functioning? Think about your own best time of day. They're in pain. They're not in pain, but they're heavily impacted by the medications that are keeping them out of pain. How are we approaching them? Are we moving too fast? Are we coming in like I'm doing right now, going fast, 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 and lots of words and lots of jargon? Or are we slowing down? Are we making sure that they're understanding? Are we causing our mere existence or the environment we're in together, courtroom, hospital room, whatever, a conference room down at the government center? Are we causing or triggering trauma responses? Are we using plain language? Are we speaking in the person's primary language, or making sure somebody is present who's appropriate to be an interpreter? Or maybe using pictures instead of words for some people. All the things. What information do we have to bombard them with everything, or go step by step? Today, we just need to talk about this part. Who else should be present? What do we know about the person's culture? That trauma I mentioned earlier, how that their past experiences, whether it's their community and historical or their own personal, how might that be impacting how they react when we from adult protection or the police show up at their door? Okay, so are we working to enhance the person's ability to comprehend? And by that, we're enhancing their ability to make the decision. And that's okay, even if they need extensive support, where they're able to make the decision. And then we don't have to we don't at least have to start with guardianship. When we're looking at the perceived decision-making disabilities, try setting aside the idea of guardianship. Just presume it's not even on the table momentarily, at least momentarily. And think about, how can we get to the source of the problem? What is the cause of that, whatever it was that brought it to your attention through APS and the MDT? That person who we think they're incapable of getting their needs met, their family caregivers are neglecting them. What else might be going on? That person who's diabetic, but there's no healthy food in the house. Their blood sugar levels are out of control, leading to yet another hospitalization. Is this a failure of the person and caregivers to meet the basic needs, self-neglect, caregiver neglect? Well, it is at base level, yeah. Does that imply they have to have a guardian and a different decision maker? Or is it that they're living in a pharmacy desert? There's no access to the medications, or they don't have financial means to pay. They're choosing food or medication. And by the way, they're in a food desert, so the only food they can get is lousy processed food. Do they have a lack of health literacy, or a lack of understanding our systems and how these complicated care and benefit systems work? Maybe they're afraid to ask questions for fear of us recognizing they don't know the answers. Maybe they're afraid that we're going to step in, remove them from their homes. Maybe we, the system, has done that to them. Maybe decades ago, we removed children from their home, or they're related to people for whom the government caused, in its well-intended efforts to do their job, caused a great deal of pain and trauma. So we have to sort through that before just labeling someone non-compliant, resistive, or labeling their family abusive and non-compliant and resistive. Hot off the presses, while I was preparing this for my comments, the National Center on Elder Abuse, which I'm sure you are all very familiar with and probably receive the same emails I do, so it's probably not news to you, but an issue brief for MDTs came out just last week when I was working on getting all my thoughts together for you, which actually address that notion that safety concerns that we carry might conflict with the person's own objectives and preferences, that our implicit biases may impact our recommendations as MDTs. So just recommend, when you have a minute, reading the information I've provided to you in the slide deck, taking a look, click on the link, save the brief, review it. It's a helpful tool. All right, so back to some more practical approaches as we sort out allegations of maltreatment, which could include, again, neglect or refusal of what we believe to be necessary services to meet a person's needs. Before possible solutions and imposition of approaches and interventions, such as guardianship, again, figuring out what's the basis for the refusal or the unmet need. It might just be that no one ever explained the importance of the issue to the person or their family in ways they can understand. They may be carrying misinformation. For example, the person who's in long-term care or needs to be admitted to long-term care and they're refusing to go, or they're planning to leave against medical advice. Looks like refusal to us, looks like, oh my gosh, we have to intervene. Look at all the things that have happened to lead them here. We have to do something because they're refusing. Well, maybe what's actually going on, and I find this a lot, is they are believing the state's going to take my house. The nursing home's going to take my house. And by the way, my house is where my beloved spouse lives. The house is where my child, which you don't view as my dependent, but I view my adult child as a dependent. You view them as lazy, taking advantage of me, but they're my kid. And by the way, they're the parent of my grandkids. And dang right, I'm using every last penny of mine, even if it means I don't get my medicine because they're my family. Doesn't make it right. Doesn't mean we can't or shouldn't intervene, but it's something we need to be thinking about so that we can address those issues and try to get at the lack of trust, the lack of compliance, what's really going on before we label it being based on an incapacity. It's our role to figure out the source of the unmet need or the bad decision and then get to work figuring out how to address that in the least restrictive manner possible. Whether it's engaging their trust and the trust of their support systems to help them understand the decision they face, whether it's figuring out how to connect them with services and a means to pay for them, like working with releases of information. So I or a family member can act on their behalf to obtain medical assistance or waiver services to pay for care, helping them understand the state's not going to just take their house. House may have to be sold, but that's a different story. It also may not have to be. There may be provisions and requirements around it. Maybe they have enough capacity to name a trusted person to make healthcare decisions for them, even if they can't understand the actual medical decision that needs to be made. Maybe they do have funds, which have been, in our view, being exploited, taken advantage of, and those funds need better management and protection. Maybe they can't do it themselves, but in meeting with an attorney, who finds them capable of entering into a fiduciary contract, like a power of attorney or trust, maybe they're willing to do that. Or maybe we do need guardianship, but maybe not a plenary one, maybe where a just one power is needed or for a short period of time to enable the decisions to be carried out for the person's protection. And then maybe we don't need an ongoing guardianship. So it's all about doing whatever it takes to address the person's challenges, their unmet needs, and their vulnerabilities in the least restrictive way, with guardianship as the last resort. Because we have historically turned to guardianship too often as the first best response to protecting people, even as we too often have, again, I'm speaking personally, too often have ignored how that impacts the person's own goals, wishes, preferences, and definitions of what makes a life worth living. So we have to acknowledge that there are benefits. Don't get me wrong, there are benefits, and risks and harms and unintended consequences. Sometimes I inadvertently give the impression that I'm anti-guardianship, and I am not. Guardianship is valuable, it's necessary. Sometimes it's the only tool for a person. We need it in order to address egregious situations that are unresolvable in any other way. Maybe we can rest assured that there's court oversight, maybe, but not always. That's why some of these things we've heard about in the news, proof that court oversight doesn't protect it, accountability to the court, maybe, but not always. The value of determining or clarifying that we have one person who's the legal decision maker to break through all the quagmire. So yeah, guardianship's necessary. I don't mean to say it's not. And I'm not going to spend more time on all the ways it's good and necessary, because if it were, it'd be a little easier, shorter conversation, because we have to recognize for enhanced MDTs, for other professionals, for APS workers out in the field, we have to acknowledge that there are realities, limitations, complications. In my state, Minnesota is a state that significantly adopted the Uniform Guardianship and Protective Proceedings Act. If your state has too, then it'll be similar in your state. In my state, and in most states, you have to at least acknowledge there's no less restrictive alternatives. You have to at least talk about it and in some way prove the need for guardianship, some level of incapacity. Minnesota takes it even further. Petitioners have to tell the court in the petition and in the court hearing what less restrictive alternatives they tried, how long they tried them, and why it didn't work. So in my state, when people say there's no time, I can't do it, you have to. You have to try less restrictive alternatives, maybe in your state too. We don't always recognize, and I've alluded to this already in earlier comments, people don't always recognize that even with all the powers that may be given to a guardian, guardians can consent to services and treatment, but it really doesn't necessarily have much ability to impact a person who has a physical ability to sabotage all the plans. A person who doesn't like being touched, doesn't like being in a memory care where somebody's trying to help them get dressed, have clean body care, showers, and they strike out and they hit and they scream and they swear because it's Guardian doesn't resolve that. Guardian just gives consent to, yep, give them the care they need, right? So it doesn't resolve some of the things. They can't manufacture a residential setting that has adequate staffing or a home care team to provide care in the home, which would otherwise be perfect, but there's not staffing levels. It's a big problem in Minnesota, and I wager across the nation as well. Because guardianship is compromising a person's constitutional right to freedom from interference from the government, there are a lot of due process protections, making it a long process to obtain guardianship. Except in egregious circumstances, most states have some ability to do an emergency imposition, and that may be needed. But the general process, by definition, takes a long time and is expensive, and it's burdensome for families. When we're asking families to serve as guardians, we're asking this to do this in some cases for decades. If it's a younger vulnerable adult, we might forget or ignore that the stress to the guardian that comes because of family discord, having to additionally deal with court reporting, being the lightning rod of anger from the person, from other family members who don't like the hard decisions the guardian's making. And what happens when the guardian themselves becomes ill or unable or just wants to retire from being the guardian, and they can't find another family member to step in because court, because intimidating, because I have my own background problems I don't want to be revealed in the course of it. So finding another guardian to step in can be challenging. And while it's true that there's an industry of professional guardians in many states, when there's no ability to pay the professional, or when a county or court contracts with one guardian and that guardian is problematic, or that guardian and that individual are just, butt heads, problems continue to grow. So there's some real practical limitations to guardianship. I've mentioned several times already, by definition, it's an adversarial process. I have found myself over the years explaining to an individual, it's okay, it's not so stressful as you might think. It's like going to court for a civil process like an adoption. I'm kind of horrified now that I tried to placate someone and calm them, good intentions, and we don't need people having psychiatric crises because I'm terrifying them with the reality. But how many times I just glossed over. And it's a nice little friendly court hearing where I'm going to ask the judge to take away your rights and give it to someone else. And the mere process of going to court, the petition, the paperwork, the showing up at court, proving the need for guardianship is going to have to, by definition, emphasize the person's deficits and disabilities. That can feel really triggering and traumatic and terrifying for people who've had, again, in the past, negative interactions with law enforcement, for example, or legal systems. So it can be really difficult. It might not offer the protection we think it does, as I've already mentioned. It does not guarantee protection from maltreatment. So there's some harsh realities we have to think of when we're contemplating. Again, doesn't mean we don't do it, but we need to be really aware. And then finally, coming back to something I've been mentioning, but I want to spell it out a little more. Too often, with really good intentions, guardians, medical systems, social service systems, we tend to emphasize safety and adherence to the best practices. This person has been historically refusing, non-compliant. Those are words I don't like because that paints a picture, as opposed to today the person didn't want to, so language. But anyway, we paint this picture, and now we have a guardian. And now, by golly, let's get that guardian to consent to that healthy diet, low cholesterol, low salt, low fat, low sugar, medications with serious side effects. Don't have interactions with that person who upset you, or maybe I don't like that person. We turn to the guardian to consent to restrictions with good intentions, safety focus. What's it mean to the individual that at the cost of that person's life satisfaction and quality of life? How many of us in this room, if we had more time, I'd say raise your hand or put in the chat, how many of us may always make the best, safest, most healthy choices? And what if someone else was suddenly appointed for our own good to restrict our access to our hobbies, our social interactions, our foods, or other things that give us life and joy, but we would be safe? Right? So we want to think carefully about that. So therefore, what I want to pivot to and think about is all the different ways we can examine helping people outside of guardianship, that we don't rush into it, that when we arrive at a place of we need guardianship, that we have truly, for all the reasons we've discussed, explored other ways of getting the person's needs met or the safety concerns addressed, ideally in the least restrictive ways. Now, you might think there's a typo. Those of you who are visually watching or who will look at the slides later, I crossed out and left in for your perusal the phrase, and I've been saying today, less restrictive alternatives to guardianship. There's another language matters. I should have called this whole thing language matters. This is another language matters issue. Trying to, when we emphasize the full spectrum, when we say decision-making options or decision-making supports, and I didn't make this up, I learned it from some really great and wise people that I admire that have been trailblazers in this area that I've learned from. When we call it a decision-making support, that recognizes an entire spectrum from complete independence to complete substituted decision-making and everything in between. And when we use less restrictive alternatives to guardianship, we're still centering guardianship as the standard, the norm, and the thing against which we compare all other options. So I try to steer away from less restrictive alternatives to guardianship and talk about decision-making options to reflect an entire continuum. Limitless ways to use combine options to support a person in this slide to address their personal vulnerabilities, their health and safety concerns. And I don't want people to think of anything I'm saying today or putting in front of you on a slide as an exhaustive list. These are just some ideas. And sometimes people ask me, well, how do we know which one to try? Well, the answer is, at the risk of sounding flippant, all of them? Many of them? More specifically, whichever one or ones will address the unmet needs is what we should try, with guardianship being tried last, except in the most egregious of situations, of course. And even then, guardianship as an emergency basis, while we still work on more stability outside of guardianship. So this might mean helping a person understand their situation, building trust and rapport with them, between them and family supporters, between them and professionals. This is under the umbrella of supported decision-making, getting them to accept services that we all think they need to address the vulnerabilities. Maybe we work to re-engage families. We coach families in how to support without being exploitative. Maybe it's helping the person appoint a healthcare decision maker or enacting the authority of a previously completed advance directive. The role of professionals, just like it's our role to enhance capacity, it's our role to serve, again, not necessarily if each person in this room, your particular role, but collectively, it's our role to be the brokers, the liaison, the gatekeepers, accessing services and supports, whatever it takes to get the person's unmet needs met. Similarly, in the financial realm, so many options to try alone or in combination. Again, it doesn't matter if the person can't figure out housing in the case of decision-making options other than guardianship of person. It doesn't matter in the realm if they can't pay their bills. Are there systems and services and supports we can pull in to get the decision made, to get the bills paid? Okay. What can we do to help support the person again without that court intervention? Maybe again, we help the person better understand their situation. Hey, if you don't pay this bill, you're going to get evicted. And you've said this apartment or this assisted living apartment is the place of your dreams and you never want to move. But if you get an eviction, we'll never find you another one. And then it's probably nursing home because they'll accept people with evictions, right? This is how we're not threatening, but we're helping you understand the consequences of your decision of not paying the bill could lead to an eviction. Maybe we're figuring out they thought they were overcharged, whatever that might mean. Maybe automatic banking actions to protect income and get the bills paid. Maybe seeking the appointment of a representative payee to manage their Social Security benefits when that's the only money that needs managing or protecting. Or for people with more money, a willingness to have help, a willingness to work with an attorney to complete a power of attorney, a trust, or maybe we do need a limited court order. So delving a little bit deeper into some of these that I've sort of highlighted in bullet points and going fairly quickly, let me just also pause. I'm also watching our time. Do we have questions at the moment, Lisa or Marty? Okay, thank you. well, then I'll keep going. Okay, so talking about starting, whoops, this is my transition slide. I'm going to skip this and move right into, as we transition into some ideas, informal interventions in the realm of building trust, building rapport. I acknowledge not everybody in the room is probably a social worker, but I'm a social worker and I like to call this good old-fashioned social work or good old-fashioned casework. What we learned to do when we were being trained on our jobs or we were being trained in social work school. Meeting a person where they're at, building, establishing relationships, trust, rapport, helping the person understand, articulate to us so we can advocate for them. What are their goals? What are their wishes? Can we find ways to balance what's important for them? That's where I come in, health, safety. I'm worried about your health and safety, and what's important to them. What's important to you, your family relationships, living in this environment. How do we leverage the important to them to ensure they also have what's important for them? The more we're partnering with them, the more we're helping them, the more likely they'll be willing and able to make the decisions we want them to make anyway. And again, it just comes back to, and I'm sure this isn't news to you, but it bears repeating. Building relationships is core. It doesn't always feel like we have time to build relationships, but we also might as well, because guardianship takes a long time too and comes with all the negative things we've talked about. So building those situations to support the client, enhance their capacity to make decisions, again, outside of situations of extreme and immediate danger, of course. Facilitating realistic goal setting. We share with them, it's okay, it's not undue influence, it's not inappropriate, it's not crossing a boundary to say, you know, from where I sit, because I do understand medical assistance, and that's really hard to understand. Can I explain a few things to you? Instead of just taking, well, they said no, now I gotta either let them be or go get guardianship. Let me bring my knowledge to the conversation. If they trust me, if we've built that rapport, helping understand the wisdom of what I know and the lack of wisdom. I don't know what's real to you. Tell me, help me understand. So building on their capacity and their willingness. And that's what supported decision making is. I love talking about supported decision making when I'm the director of a program called Center for Excellence in Supported Decision Making. You can imagine I'd like to talk for 3 hours on this topic alone, but just honing in very quickly, high level overview, a definition for you from attorney Robert Dinerstein. Some of you might know him. I love his definition as it's a series of relationships, practices, arrangements, agreements, more or less formality and intensity, anything we do to assist an individual with a disability to make and communicate to others, if they want that, decisions about their life. It's beautiful. It can be written down. It doesn't have to be. It can be Lisa coaching me through how to get these doggone slides to be the way I want them to be before we do a presentation like this. It can be me saying, I give up. I'm too stressed. I can't do it. You do it for me, please. Right? That's supported decision making or supporting me in getting my need to have a successful presentation done. So it's what we all do all the time for ourselves, for others. And these are just some fancy definitions. And in Minnesota's case, it's in the law. And in many of your states, it's in the law. And in Minnesota, we have to try supported decision making as a less restrictive alternative before pursuing. The principles, the philosophical underpinnings, it's not necessarily a tool, a written agreement, it's a philosophy, it's an approach, it's the knowledge that when supported, most people can make decisions that are necessary and that balance what's important for them, such as health and safety, and what's important to them, such as how they spend their time, their relationships, their jobs, and so on. Anecdotally, we know this, research backs it up. Older adults and people with disabilities who have greater self-determination are found to be statistically healthier, more independent, more well-adjusted, more willing to have more help and services, and get this, MDT professionals better able to recognize and resist abuse, and more heard and understood, and believed, I should say, when they don't have guardians. It's too easy to write people off when they have guardians and they're reporting something that looks abusive. benefits of choice, support, the benefits of choice and support versus taking away people's rights. People, I've alluded to this, we impose something on them for their own good, may result in us seeing more resistance, more non-compliance. I don't like those words. More reaction, more intrusive behaviors, people striking out. Their frustration and their anger is communicated as striking out, or curse words, or pulling inward and refusing and becoming isolated and depressed, right? So these things that happen to people when someone else tries to tell them, I know what's best and this is what you need to do. And in fact, the flip side of that, how much more capable, capacitated people are, ironically, even despite their level of disability, when they retain that sense of agency, even if it means we have to help them significantly. People do sometimes, professionals sometimes confuse person-centered approaches and supported decision-making into believing, they sometimes think, well, we just have to accept it. They said no, and they're their own guardian, which I don't like that term either, because that sets the standard. Everybody's either their own guardian or they have a guardian. How about they're legally entitled to make their own decisions, which is more of a mouthful. Anyway, we just sometimes go, well, they're their own decision maker, that's that, and leave them, abandon them to their choices. Or they say they're, demanding something that's important to them, and then we think we have to do protective interventions. That's not what person-centered approaches or supported decision-making are about. That's really a fallacy. It's about don't just take no, working with the person to help them understand their situation, the consequences of their actions, how it'll impact their goals. Use our knowledge and experience to partner with them. Again, not a particular tool, but an approach, a way we work with people, and then apply all the different tools that are out there. Working with families, it's so easy to view families as the bad guys. They are the abusers sometimes, or they're part of abusive systems. They're also part of communities, and they may paradoxically be an asset to the individual. They may be a support. And the more community people have, the less isolated they are with just a single family member or a single designated decision maker. The more community, the less isolated, the more quickly maltreatment can be recognized and responded to, more opportunities there are for responses. We might need to re-engage families. We might need to not just say, well, how often have you heard their family's estranged, so no family, go on down the next road. But we want to, again, similarly, as we've talked about with the person, what's the reason for the disengagement? If the person's willing to talk to us, if the person we're serving is willing to allow us to talk to family, but there might be some significant reasons for estrangement, like the individual who the son or daughter, adult son or daughter, is out of the family because they themselves were abused by one of the parents who's no longer even in the picture. So maybe now they're willing to be re-engaged. They had to step out for their own mental health. And now, oh, mom or dad or grandma is in a pretty perilous situation and needs some support. I'm in, I'm back. I'm back. I've had therapy. I've had distance. I'm here. So don't just accept estrangement as the end of the story. Or maybe a trusted advisor, a spiritual leader, somebody from the community, an elder, depending on the culture, a physician, all about helping build that community. And that is our role. It's, even though the client is our person, they're a part of a system. And so supporting that system is what's going to have the best outcomes for people. Using bank interventions, direct deposit, auto payment, having the person still feels the sense of, I'm still in charge of my own money. But okay, fine. My trusted friend, Lisa, we'll set it up so she has a password. She can watch what I'm doing on my bank accounts, and she's not going to step in because we agreed she won't. But if my trusted person sees there's a concern, they're going to come to me, or they're going to come to someone else that we've agreed on previously. They're keeping an eye on things. And then maybe they're going to take over if it's egregious enough and I've previously given them the authority to do so. So all the things that we can do informally to support people. And then, of course, our formal interventions. And again, last month you had a brief overview of advanced directives, or again, depending on what your state calls them in Minnesota, healthcare directive, healthcare power of attorney, advanced directive for healthcare, whatever it's called in your state. We look to not just to guardianship first, but first, if we need a legal tool, has the person previously completed one? That's nice and easy. And now we feel they're incapacitated to make a particular medical decision. Then we get the authority triggered. That might mean a physician or two physicians, depending on our state, and the document saying, yep, they're incapacitated, trigger the authority. But don't forget the ability for a person, even with impairments, to make a new document. Maybe they understand that, again, now I'll pick on Marty, even though they don't have their camera on. I'll pick on Marty. Let's say I want Marty. I can consistently, reliably say, this is my person. If I can't make a decision, I trust Marty. I may not understand or even think I want help with medical decisions, but if I can appoint Marty, that's legal capacity. In most states, it is in mine. But we have to have an available appropriate person to serve. We might want to ideally have an alternate. I want Marty, but Marty's not always available. So then I want Kylan to be able to step in if Marty's not available. And we can build in protections. Even if we think this person that the client wants to name was part of the maltreatment, maybe they were part of maltreatment on a financial thing, but maybe they're still a really good medical decision maker. Maybe not, but don't rule it out. Right? Do you have a question, Marty, or did it just come on because I picked on you? Okay, keep going. Okay, and then similarly, the corollary, the financial power of attorney, which again, corollary to the healthcare power of attorney. So again, person has capacity to understand, person is willing, they want help, there's somebody trustworthy. I strongly advise, I train attorneys. I've done this over 34 years. I don't help people complete healthcare directives. Attorneys. But we can build in protections. Again, caution, high potential for further exploitation with a power of attorney. So we have to be extremely careful. Another reason to use a lawyer. They can build in extra protections. Maybe we need to connect, whether it's going back to the healthcare decision maker or the financial AIF is attorney in fact. That's the language in Minnesota if a person is appointed under a power of attorney. Maybe we need to coach them and guide them and give them training and support so they can do the best job. And maybe I mentioned earlier, representative payee. We move into, again, we're in that formal legal decision-making tools now. Maybe, and this, a lot of people don't know, you can do representative payee requests to the appointing agency, Social Security, Veterans, Railroad Retirement Board, even involuntarily. People can have a payee appointed even over their objections. They have a right to appeal. A physician has to weigh in. There's protections. There's accountability by having to report to the government agency. Again, doesn't mean things won't happen. And there's mechanisms to report and get a change if we need to. But that's another opportunity. Finally, when we get to guardianship consideration, what should we be asking ourselves when we're thinking guardianship, or what should we have explored? Can it be met in needs met in any other way? Does it meet our particular state's statutory criteria? Can the authority even impact the identified need? Is there someone that can serve? Can we limit it? And then the proportionality considerations. Will the benefit that we gain from guardianship outweigh removal of rights, outweigh harm to the person, exacerbation of symptoms, and intrusive behaviors because of the impact of having that imposed on them? If we can't answer yes, then we probably shouldn't be doing it if we're causing more harm. And that can be controversial, but I really hope that people sort of have that in the back of their heads when they're navigating through. So I have in summary, I told you what I was going to tell you. I told you, and here's what I did tell you. We can talk about this quickly, but I also want to give space. I think I saw that there was something in the chat. Do we have questions or chat, or should I just quickly run through our closing slides? Closing slides, Lisa's saying. Okay.
There's nothing in the chat. It's just the feedback survey link.
Awesome. Perfect. Thank you. All right. So we
may have questions.
And we might have questions. Yes, you get to have questions just because it's not in the chat. So I'm going to keep talking until one of you interrupt me. Sound good? Okay. So as we talked about today, we want to be reflective of, we have historically overused guardianship. We have historically looked at people's need for this invasive intervention with our ageist or our ableist lenses. We sometimes forget that they're a whole person with a life history of resiliency that maybe need extra support, but doesn't automatically mean they have to have a guardian. We recognize that we have a plethora of less restrictive ways, a whole supported decision-making option, scale. That doesn't mean court involvement. better chances of preserving relationships, whether it's between professionals and the client or the client and their family, or all of the above. Usually less expensive, almost always better outcomes for the person. We can address those vulnerability issues with options other than guardianship. And it's required, if not by law in your state, which it probably is, then by our federal laws, our ethics, our professional standards and practices. So taking away, even people with significant impairments may still be able to participate in decision-making. Supported decision-making can enable people to retain their rights, find the balance of health and safety alongside choice and quality of life and dignity of risk. And we're required by law to avoid it in government interventions whenever we can. Lots of resources. Some of these were in the announcement for today's training, and then I since supplemented, and I couldn't stop, but I forced myself to find the most key articles and videos and trainings I wanted to share with you today to cement what we've talked about. And then I want to leave you with one of my favorite quotes from the great Dr. Atul Gawande, who wrote a book several years ago called Being Mortal. And his purpose of this book, his thesis, his desire and goal was about reshaping long-term care, medical care at the end of life. So therefore I'm stealing from him and misappropriating. It's not misappropriating, I'm reappropriating to our purposes today because I think it fits. I think it's a nice way to end our conversation together. I don't like the term the sick and the aged, you might have guessed, but that's his quote, and he said it a long time ago, and we all evolve. But our quote, our most cruel failure in how we treat the sick and the aged is the failure to recognize that they have priorities beyond merely being safe and living longer, that the chance to shape one's story is essential to sustaining meaning in life. And he goes on to say, we have the opportunity, and I think it applies to MDTs as well, and adult protective services systems. We have the opportunity to refashion our institutions, our culture, and our conversation in ways that transform the possibilities for the last chapter of everyone's lives. Thank you. And we have a few minutes if any questions have emerged.
I'm looking through to see if anybody's name is up. No, hand up. In the chat, I put the link for the feedback survey. If you could just click on that and give us your feedback, that would help. Thank you, Anita. That was very, very insightful. I loved it.
Good. I'm glad you loved it. Hopefully it was helpful. I acknowledge it can feel controversial. Please share all feedback, and I trust that Marty or Lisa or Kylin will get back to me. I acknowledge this can feel new. This could also feel like, why are you here? This is what we do already. And if so, that's fantastic. But I'm so happy to have spent this time with you, and thank you. Thanks for having me. And let me know if there's questions. Marty knows how to get in touch with me.
Thank you.